Welcome, everyone, to the Firearms Research Center's virtual seminar number 12. As many of you know, one of our missions at the center is to get as many voices and as many views and as many topics covered that relate to firearms and get information out to the world about that. And one way in which we do that is our webinar series. We have a special format today. Joe Greenlee will be our host, and we'll be doing a Q&A format where he'll be asking some questions, and I'll be answering them about an article I wrote for the Texas Review of Law and Politics on the firearm rights of young adults, which I think has broader applicability ultimately than just firearms. Some of you, if you tuned in this past Friday on the 18th, this video is very similar to that, but because of a technical error, we didn't get a recording of that session. So this one will cover the same topics. We're going to use transcripts and such to try and recreate that one. But if you're watching this rather than attending last Friday, you'll need to register, put in your CLE credit for this one, which is separate from the last one because it's not an exact copy. And presumably you're seeing this on the FRC's website under the video library. Right under the video, there should be a link to the CLE page for this video. So I'll start by giving a short bio and then turn things over to Joe. So Joe is the director of the Office of Litigation Counsel at the National Rifle Association Institute for Legislative Action. He's one of the nation's top Second Amendment litigators, if not the top litigator. Joe has worked on over 140 Second Amendment cases, filed more than 40 briefs with the U.S. Supreme Court, and I've actually had the honor of joining him on several of those briefs. He's authored 18 scholarly articles on firearms law and has been cited in over 150 cases, including 5 U.S. Supreme Court cases. One of his U.S. Supreme Court cites was of an article that he wrote for the Wyoming Law Review, so we're rather proud of that here. Joe has also authored dozens of short articles on the right to keep and bear arms, which have appeared in The Hill, Washington Post, and several other outlets. And with that, I will turn it over to you, Joe, to be our master of ceremonies today.
Well, thank you, and thank you everyone for tuning in. This is in addition to an Firearms Research Center CLE. It's also part of a video series in which I interview authors about their Second Amendment scholarship. If you'd like to see other interviews, they are posted to the National Rifle Association's YouTube page, and then also on the Firearm Research Center's forum on the website. For this interview, I'll be interviewing George Mocsary. George is a law professor at the University of Wyoming College of Law. He's the founder and director of the Firearms Research Center, housed at the University of Wyoming College of Law. He's a co-author of the first ever law school textbook on the Second Amendment, as well as the author of over 30 scholarly articles, many of which focus on firearms law. His scholarship is frequently cited, including by Justice Alito and numerous state and federal courts, including 2 cites and different cases decided by the Iowa Supreme Court within just the past couple of weeks. Today, we'll be discussing his article published in the Texas Review of Law and Politics entitled Treating Young Adults as Citizens. It's great to have you, George. Thank you for your time today.
Oh, thanks for having me. It's my pleasure.
So the issue of whether adults under 21, that is American citizens aged 18 to 20, are protected by the Second Amendment is a leading issue in Second Amendment litigation. I'm not alone in thinking that it'll be one of the very next issues, if not the very next issue that the U.S. Supreme Court addresses. In fact, there are currently 2 cert petitions pending before the U.S. Supreme Court involving restrictions on 18 to 20-year-olds. Can you explain how lower courts have been treating this issue?
Yeah, so there's quite a split out there, and I think I'm one of the folks. I think this may you never really want to read the Supreme Court tea leaves, but this one is ripe for a cert grant. There are 6 cases out there among the federal appellate courts. The 3rd, 5th, and 8th circuits struck bans on young adults arms possession or arms rights bans. The courts essentially said that these are adults who are part of the community with rights, and there's no historical tradition of restricting their rights based on their age. The Fourth, Tenth, and 11th Circuits, on the other hand, upheld bans. The Fourth and the 11th Circuit upheld the bans on what I like to call the infancy theory, which perhaps we'll get to later. This notion that because 18 to 20-year-olds were considered infants, a technical legal term, at the time of the founding, they essentially didn't have any rights that they could assert, and their firearms rights could be curtailed because, for example, they couldn't contract or something like that. That was a common analogy, right? They didn't have the right to contract, so they didn't have firearms rights either. That was the Fourth and 11th Circuit. The 10th Circuit said that it was a commercial regulation that's presumptively lawful. Commercial regulation on the sale of firearms that's presumptively lawful under some language that Heller used that keeps coming up a lot. And what I'd say is that one place these cases fail is in choosing the right level of generality. Some scholars and some jurists complain that Bruin didn't lay down the level of generality at which to perform its historical analysis, but I would say that that's false. Bruin, in fact, talks a great deal about how to analogize, much more than it should have to, really explaining what every first-year law student learns. We can get into that later on if we have time. For now, though, what's relevant is that Bruin explicitly contemplates that society changes to face different problems, and although quoting Bruin here, its meaning is fixed according to the understandings of those who ratified it. The Constitution can and must apply to circumstances beyond those the founders specifically anticipated. This is a basic statement of what a constitution has to do, right? So, in other words, if there are closely matching analogies, statute, court cases on those statutes, and other things that go into common law reasoning, a modern court should use those in determining whether a given challenged regulation is constitutional. If there are not, then it's okay to abstract up until you find one that fits. And so in these cases, the courts had available to them a variety of laws discussed in the article, informing whether 18 to 20-year-olds, young adults as I interchangeably call them, had arms rights and responsibilities. But instead of relying on those, the courts abstracted up to higher laws impacting young adults that restricted their rights, and relied on those to uphold the modern laws that were being challenged. But that abstraction was improper, given that there was law that could be relied on with no, or at least much less abstraction, law much closer to the laws at issue here.
So under the title of the article, you provide a quote from John Stuart Mill warning that the tyranny of the majority is among the evils against which society is required to be on its guard, and explaining that it chiefly operates through acts of the public authorities. What's the relevance of this quote to the question of whether adults under 21 are protected by the Second Amendment?
Yeah, so what Mill is doing here is restating the very important principle that the Constitution, any Constitution really, is an anti-majoritarian document. So James Madison talked about this in the Federalist Papers, where he said that the Constitution is a barrier against the, quote, superior force of an interested and overbearing majority. In other words, the point of a constitution is, quoting Heller here, to take certain policy choices off the table. In other words, no matter how good some policy looks, right, individual rights trump. No matter how much the majority might not like or trust that particular group at issue, that group still has rights. Young adults comprise just 4.2% of Texas's population, and they have little or no legislative representation. But the Constitution protects them too. They're full citizens who can die for our country, vote, and be subject to every kind of criminal penalty, including capital punishment, including in Texas. But judges are human, just like legislatures, or legislators, I should say. And so why should we expect parchment barriers, words on paper, that's a quote from Madison, parchment barriers, to immunize judges any more than anyone else from the the encroaching spirit of power, right? Again, to quote Madison here. So Alexander Hamilton talks about this, and he says, quoting him again, it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative invasions of it have been instigated by the major voice of the community.
You start the article with a summary of District of Columbia versus Heller, the Supreme Court's first in-depth examination of the Second Amendment, decided in 2008. Can you please summarize what that case was about?
Yeah, so Heller was the famous 2008 decision that clearly and directly said that the Second Amendment protects an individual right to keep and bear arms unrelated to malicious service. The Supreme Court had touched on the Second Amendment before. It had hinted at things, but this is the first one where it really directly answered that question. And its two important holdings were one, that one could keep a firearm in the home for self-defense, and two, that the firearm had to be functional and accessible. And just kind of a small comment here. Sometimes it's said that it only protected a handgun in the home and not a long gun. Well, in striking a DC law that said that long guns kept in the home had to be disassembled and non-functional, the court implicitly said that long guns are also protected. It wouldn't have had to address whether that law was constitutional if long guns didn't receive any protection. So that's just a point worth remembering there. But more importantly for our discussion today, Heller's analysis strongly implies that the Second Amendment protects the bearing of arms outside the home. For example, just to name a few points of this analysis, Heller holds that the Second Amendment protects, quote, an individual right to possess and carry weapons in case of confrontations, most of which are not limited to the home in a world where it's all but impossible for one not to leave the home, as we learned during COVID, for example. Um, it lists a number of long-standing, presumptively lawful arms-bearing regulations. And these phrases are worth remembering. Long-standing and presumptively lawful are terms that come up a lot in Second Amendment cases from Heller here, including laws forbidding the carrying of firearms in sensitive places. That phrase, sensitive places, is another one that comes up a lot. So it said that these were presumptively lawful without sanctioning a general ban on public carry. Suggests that some regulation of arms carriage outside the home was not presumptively lawful. And it relies on 19th century case law that held that the right to bear arms mandated the legality of either concealed or open public carriage. So if a state or locality banned one, it had to allow the other.
After Heller was decided, a lot of supporters of gun control fretted that the decision would require lower courts to invalidate virtually every gun control law on the books. How did the lower courts treat the Second Amendment after Heller?
Yeah, so this is a topic about which I've spoken and written quite a bit. Despite Heller's implication that the Second Amendment protects arms bearing outside the home, the judicial response to claims asserting a right to carry a firearm in public has ranged from a mild confinement of government infringement to a may issue permitting regime. May issue means essentially that the government authority that issues a concealed carry license has a great deal of discretion, sometimes unlimited discretion, typically in practice unlimited discretion in who it issues a license to. Whereas shall issue means that if you're not a criminal, you're mentally sound, and you've typically taken a safety course, the issuing authority has to issue you a license. So from mild confinement of government infringement to a may issue regime to outright defiance of decades of fundamental right jurisprudence. Most employed a watered down version of intermediate scrutiny, which in some cases has been more deferential than even rational basis review, and really just summarily to uphold gun laws. So what's my evidence of this, one might ask. So I can describe some cases for you, but in fact, In some sense, I don't need to because judges tell us in the form of open hostility in both judicial opinions and their external writings, including by judges who have ruled in Second Amendment cases. So we might, for example, initially want to believe that a Supreme Court justice performed an intellectually honest analysis of the Second Amendment's history in Heller to conclude that it's some kind of militia thing and it, doesn't exist anymore. It's not an individual right. We might begin to doubt that justice's sincerity upon reading an opinion piece in the New York Times in which he writes that pro-gun control demonstrators should, quote, demand repeal of the Second Amendment because it's a, quote, relic of the 18th century. A Court of Appeals judge who ruled in Second Amendment cases wrote that there's no duty of candor in judicial opinion writing. And maybe it's worse when it's in the opinions themselves, as we've seen in judges from the Fourth and DC circuits. We've also seen it, quite a bit of it post-Bruin from a judge in the Southern District of Mississippi, just really expressing open hostility to gun rights, to the Supreme Court for holding that the Second Amendment protects an individual right, and so on. And I think given this and how intelligent and skilled our judges are, we should rationally expect more defiance than we can readily see to be masked with pretextual legal analysis. Um, uh, and indeed, we have good circumstantial evidence of that. So the lower success rates of Second Amendment cases subjected to heightened scrutiny. Um, uh, there were some studies done that looked at the success rates in Second Amendment cases, according to one well-known study, was 19% and 10% for strict and intermediate scrutiny, which courts are purporting to apply in unaltered form, versus about 70% or 88% for the universe of strict scrutiny cases, depending on exactly which studies and cases you look at, and 74% for intermediate scrutiny cases. There's a substantial set of cases that purport to apply heightened scrutiny, but then explicitly apply rational basis review that Heller forbade, or the equally deferential reasonableness review. Whenever a court says regulation X is reasonable, it's really applying rational basis review. There's a pattern, there was at that point, and this has continued a bit, a pattern of burdens being shifted from government defendants to right holders. Whenever the court says such and such plaintiff has not shown, that means the burden is being put onto the plaintiff, and this is past the prima facie stage. There was also a pattern of courts hearing and rehearing cases until the court's desired outcome is reached, with the Ninth Circuit going as far as multiple times granting sua sponte en banc review, even when none of the parties in the case requested, or none of the parties petitioned for en banc rehearing. And also a pattern of courts neither applying historical analysis as Heller requires, nor relying on precedent that does. The article we're discussing now cites many of those, both directly and by referring to a 2018 law review article in which I devote a lengthy footnote to instances of judges openly expressing their hostility to the Second Amendment. There have also been others since, several of which are cited in the article we're now discussing.
Speaking of the cases that you address in this article, the one that you really focus on is Drake versus Filco. What was that case about, and why did you find that one significant enough to spend so much time on out of all of the Second Amendment cases decided before 2022?
Yeah, so the Third Circuit case of Drake versus Filco is the one that I found to be most defiant post-Heller and pre-Bruin. And at issue was New Jersey's very restrictive May issue statute. It had a very high standard for issuance, which sometimes, people who were facing threats didn't get licenses. It really was entirely up to the issuing authority, entirely discretionary. And the penalty for carrying without a license, the minimum penalty was quite high. I believe it was 3 years as opposed to, for example, 1 year in New York State, or New York City, which already is considered to have, some of the strictest gun laws in the country. The court in Drake first applied what came to be known as the two-part test. So, little explanation here. And under the two-part test, which developed after McDonald, which incorporated the Second Amendment against the states, a court would first look at and ask how whether the conduct at issue is protected by the Second Amendment. And if the court said no, it's not protected, then the case was over and the plaintiff lost. The rights asserting plaintiff lost. If the court said, well, yes, it is protected by the Second Amendment, then the court applied some version of heightened scrutiny. And it picked the level based on how close the asserted conduct, the conduct that was asserted to be protected, was close to the core of the Second Amendment right. And one scholar out there described that as glaringly circular, and I think that's right. But anyway, that's the test that was picked up by all but one circuit that addressed it. In Drake, the court first held that public carriage fell outside the scope of the Second Amendment's protection because the New Jersey statute's justifiable need requirement was longstanding. Yet, even if Heller's presumption of legality is based on the longstanding nature of a regulation, a questionable assertion, I think, because Heller did not say that longstandingness drove the presumption, though perhaps you can read a part of McDonald to suggest that. But in any event, the Drake court made no serious effort to address the plaintiff's argument, rebutting the presumption that a longstanding law is constitutional. And after all, as the Third Circuit said in another case, quote, saying that there is a presumption necessarily assumes that it can be overcome in some cases. If to say that something is an irrebuttable presumption is really just to say that it's a rule of law. Okay, so the First Circuit, the Third Circuit first dismissed the plaintiff's argument that either open or concealed shall issue carry had to be allowed, with a conclusory statement saying that it didn't, without addressing Heller and the implications in Heller, some of which I mentioned. And then it combined the New Jersey statute's 1924 pedigree with the assertion that felon in possession bans sanctioned by Heller were enacted in the same era to conclude that the law was longstanding. But as the dissent points out, New Jersey allowed open carry until 1966. And to quote the dissent here, felon in possession laws have historical pedigrees that originated with the founding generation. End quote. And that's exactly right. The disarming the dangerous is something that clearly has its roots back in the founding generation. Disarming everyone did not. And the majority made no effort to explain away these complications. But then the Drake majority performed an alternative analysis under what it termed intermediate scrutiny, but which was actually more deferential than even rational basis review. So under the Third Circuit's version of intermediate scrutiny, the state bears the burden of showing that a given regulation does, quote, not burden more conduct than is reasonably necessary in attempting to achieve its stated end. And most significantly, the court relied entirely on the, quote, predictive judgment of New Jersey's legislators, end quote, that limiting issuance of carry permits would enhance public safety. And that predictive judgment was, to quote the dissent, based on no evidence at all, truly no evidence, not even a scintilla, nothing. It didn't even bother to quote, a hair of empirical evidence on that point. And so how could it do that? Well, the majority said it could do that because when New Jersey passed its statute, Heller had not yet declared the Second Amendment to be an individual right, and that the New Jersey legislature, therefore, could not have been expected to know that it should marshal evidence to support its law. But a governmental entity can present, and a court can consider, in fact, a governmental entity has to present, evidence outside the legislative record when evaluating a law's constitutionality, as happened in another Third Circuit Second Amendment case, United States versus Mocsary. It was a case about a man who had firearms with obliterated serial numbers, um, which the Drake majority cited 23 times. That's a case in which the court looked outside the legislative record to and the to to support the ongoing justifiability of the law. And so the Drake court here didn't explain why it was acceptable for New Jersey not to present evidence to support the continued justifiability of its prohibition, now that Heller, in fact, had said that the Second Amendment protects an individual right. So understand, it's important to understand what this is really saying. If this is a rule of law, then Brown v. Board of Ed doesn't apply to jurisdictions that segregated their schools before Brown v. Board of Ed was decided, because, well, the legislatures that segregated the schools didn't know that this would be constitutionally infirm later, and so it can keep doing it. Same thing with Obergefell. Any state, which is to say all of them, that didn't allow same-sex marriage before Obergefell was decided could keep on not allowing same-sex marriage because, well, they didn't know that Obergefell would come in later and say that same-sex marriage had to be recognized by the states.
So in 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. The issue in that case was whether the Second Amendment protects the right of ordinary Americans to carry firearms in public. But the court also clarified the proper test for Second Amendment challenges that lower courts should be applying. What did Bruin say about the right to carry, and how did it describe the test that lower courts should be applying?
Yeah, so Bruin said that the Second Amendment protects a right to carry a firearm in public. And the core rule, I would say, from the case is that discretion in who can carry or who can exercise more broadly the Second Amendment right is not allowed. And a great quote from the case is, quote, "We know of no other constitutional right that an individual may exercise only after demonstrating to government officers a special need," end quote. And I think that's exactly right. I think it's self-evident. That's just not how rights work, right? Means and scrutiny and the two-part test, both of them are gone. Despite the popularity of this two-step approach, it is one step too many, said the court. Judicial interest balancing is not allowed, in other words. And a corollary of this, explicitly stated in Bruin, is that the judiciary may not defer to legislative interest balancing. And relatedly, the court made clear that the burden of proof is on the government here, not on the rights asserting plaintiff. And just a side comment here. I think this turned out the way it did because lower courts were so brutally abusing means and scrutiny, as we talked about, and as I gave an example just a moment ago with Drake v. Filco. Had lower courts applied heightened scrutiny or means and scrutiny in a meaningful way, the construct may very well have survived in the Second Amendment space. After all, the burden of proof is supposed to be on the government, even under tiered scrutiny, but it frequently wasn't administered that way. And, for decades, scholars have been talking about upholding Second Amendment rights under a model that very closely, or maybe even exactly, resembled the heightened scrutiny or tiered scrutiny model used in the First Amendment. But here the court saw some abuse, I think, and so it did away with the second part of the two-part test and made explicit that, as should be the case with constitutional rights, the government bears the burden. In other words, this is the court asserting its authority here. The core test is text as informed by history. That's a quote from Bruin, text as informed by history. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government then has to justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearms regulation. So far, this is nothing special, right? If a Fourth Amendment plaintiff said, sued, on the ground that, quote, "the police officer stared at me for half an hour while I ate dinner," end quote, not really quoting actually any plaintiff, but if that was the assertion in the litigant's complaint, the court would dismiss the complaint because staring at a person in public It's neither a search nor a seizure. So there's no Fourth Amendment issue in that case. So what history matters most? And the court looked at 5 eras here: medieval to early modern England, the American colonies and the early republic, antebellum America, Reconstruction, and the late 19th and 20th centuries. As far as England goes, the court said that English practices that were adopted by the founding generation, that prevailed up to the period immediately before and after the framing of the Constitution, that's a quote there, and were accepted on and acted on and part of the colonial law and culture, are relevant. The colonial period is relevant, colonial and founding periods, I should say, not just colonial period for the English laws. It's very important that the founders adopted the English laws and practices as well. The colonial period is relevant to the extent that it informed the original understanding of the Second Amendment. Antebellum America, the court said, is a critical tool of constitutional interpretation. That's a quote, to determine the public understanding of a legal text in the period after its enactment and ratification. Reconstruction, this period is important because of the 14th Amendment's incorporation of the Second Amendment. But what if the so-called Second Founding's meaning of the right to arms is different from the first foundings? If 1868 is different from 1791, it didn't matter here because evidence of a robust Second Amendment right to bear arms during Reconstruction was just as strong as it was for the original founding period. In fact, vis-a-vis personal self-defense, there's arguably much stronger evidence around Reconstruction. It's a bit of an open question. MacDonald said that incorporated rights keep their 1791 meanings, but the majority and Justice Barrett concurring in Bruin suggests that a different 1868 meaning might be relevant. The Rahimi case, which came later, the most recent Second Amendment case decided by the court, it didn't address the question. I think appropriately so, given that it wasn't at issue there and it wasn't a case or controversy. And then on the late 19th and early 20th centuries, the court said those don't provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. So how is the history applied? Well, by analogy, the court goes into this in some detail. One might ask why. Again, I think this is an attempt to head off more defiance. The court laid out basic rules of analogizing, which any lawyer knows and it shouldn't have had to do were it not for the abuse of the two-part test that I mentioned earlier. This is stuff that any law student knows, right? So, for example, quote, courts should not uphold every modern law that remotely resembles a historical analog because doing so risks endorsing outliers, for example. I think the court's analogizing can be boiled down to what it referred to as at least 2 metrics, and the at least part is important there because one can bring in others, but it focused on how and why the regulations burden the right to armed self-defense. And how means, quote, whether modern and historical regulations impose a comparable burden on the right of armed self-defense. A good example of this is the court says that, look, based on this 19th century precedent, a state or a jurisdiction could ban open carry or can ban concealed carry, but not both. One of them had to be allowed. Why means whether the burden is comparably justified. And I think this is the more interesting and important one. Its negative aspect will come into play, I think, from 2 angles. First, it prevents historic burdensome laws enacted for one reason from being used as the basis to impose burdens for other purposes, like just for its own sake, right? So there's one attorney at a gun control organization wrote that, quote, militia and fire prevention laws impose substantial burdens on founding era gun owners, end quote. And he believes that courts should uphold similar regulations, quote, regardless of the underlying motivation for regulation, right? Bruin says no to that. Second, the why inquiry, and I think more importantly, this one, it'll cause historical restrictions passed for later unconstitutional reasons to face a greater hurdle in justification. So, for example, the postbellum laws banning all but expensive military revolvers that were passed for the racist reason that freedmen wouldn't have gotten them from past service and couldn't afford them. Those are unconstitutional now for sure under Bruin.
So, like Heller, after Bruin was decided, it led to concerns among gun control supporters that it would lead to the destruction of virtually every gun control law in the books. Have we seen the same level? Well, I guess, has that happened? Or maybe have we seen the same level of defiance post-Bruin as we saw post-Heller, or is it perhaps somewhere in between?
Yeah, so it's a mixed bag that I think it's best looked at in two silos, courts and legislatures. We have seen some really extreme defiance from courts, right? Primarily in hostile jurisdictions soon after Bruin was decided. I list some of those in the article's notes, and there was one that didn't even acknowledge that the Second Amendment was an individual right, one coming out of New York. There have been similar decisions since the article was published, but we have also seen Bruin make a difference. So a comparison of three studies of Second Amendment claimants' success rates, one from 2018, this is the one I alluded to earlier, and two from 2023, shows that challenges to laws disqualifying firearms possession on criteria like criminality, false statements in firearms purchases, most of the federal prohibited person criteria in Section 922G, and machine guns. And these are together a supermajority in the claims of all the data sets, succeeded at a similar single-digit rate pre and post-Bruin. So courts are both agreeing with each other on these main issues post-Bruin and agreeing with their pre-Bruin selves. And I think on most of these questions, that's generally right. And there are some exceptions that we could talk about there, especially with the 922G disqualifiers. But generally speaking, I think those cases are correct. The claims with larger changes pre versus post-Bruin and with less consistency between courts post-Bruin, with success rate ranges going from 0 to 17% to 33 to 60%, include age-based restrictions, especially relevant for us today, of course, license requirement, bans on so-called assault weapons, and really broad location restrictions. And so this change suggests that Bruin has been at least partially successful in curbing decisions based on judicial hostility to arms rights. Age-based restrictions, as I discuss in the article, are especially unjustified and morally questionable. In fact, I might even say that the success rates for some of these types of claims are not higher, is a sign that Bruin has probably only been partially successful in curbing post-Heller style defiance. Now, we've also seen extreme defiance from legislatures. In the 6 states impacted by Bruin that required special need or may issue, which are all of New Jersey, Hawaii, and Maryland, and parts of New York, California, and Massachusetts, all are either defying Bruin or will be when their laws go into effect, and they may have all gone into effect as of late, actually. New York's bill, which was the model for the rest of them, was passed after New York's governor sent a, quote, message of necessity, a term in the New York State Constitution, to avoid the state's constitutional requirement that the legislature, and the public for that matter, has to have 3 days to deliberate over proposed legislation before it can be voted on. And she and many legislators said that it was too urgent not to pass immediately. I thought that a very odd or disingenuous claim, given that the law wouldn't take effect for another 2 months. Right? When one reporter asked, "Do you have the numbers to show that it's the concealed carry permit holders that are committing the crimes?" she replied, quote, "I don't have to have numbers. I don't have to have a data point to say this is going to matter," end quote. When asked where permit holders will be allowed to carry, she replied, quote, "Probably some streets." Um, uh, I'll discuss one of the features of these laws that were passed, again, in the interest of time here. Some of the features have been stricken, some haven't. But the one that, is probably most egregious and most well known is the private property rule, colloquially called the vampire rule. And that provision of the law, I should say, says that bringing a gun onto private property is a felony unless the owner posts a permission sign or expressly grants permission. And so that's where this term vampire rule comes from the myth of vampires, that for a vampire to enter someone's home, he or she has to be invited in, right? And this provision was stricken by all courts that heard it, except for the Ninth Circuit. Ninth Circuit upheld it, not surprisingly. But as the New York Federal Trial Court that addressed it pointed out, with this prohibition, New York is making a decision for private property owners that they're perfectly able to make for themselves, right? And in fact did before the Concealed Carry Improvement Act, or CCIA, was enacted. More importantly, it turns the way these things work on its head. It's difficult to say how carry in public is allowed if the default is that it's not allowed in a public accommodation like a business, right? No one is saying a business can't post a sign saying, please don't come in with your gun. This just turns the default rule right on its head. To make the provision worse, it exempts police officers, off-duty police officers, and retired police officers. So why do I say that makes the provision worse? Well, it's not because these individuals are exempt from it, but it shows the disingenuousness of the law in question. If the provision were really about respecting the rights of property owners and allowing them to make informed decisions, and that was the justification for it, about firearms on the property, then all situations that didn't involve a justified trespass, a police officer responding to a situation, a live situation, would require the property owner's permission. If this were really about property owners' wishes not to have guns on property, then certainly off-duty and retired police would not be exempted from the requirement that property owners give affirmative consent to firearms on their premises. Neither should on-duty police stopping in for lunch, for example.
You mentioned that several lower court judges have complained about Bruin. While some judges profess confusion about how to apply Bruin's text and history test, others have flat out criticized the test itself. What are these judges' criticisms? And for the ones that express confusion, what do they find so challenging about it?
Yeah, so the post-Bruin defiance that I mentioned has been accompanied by lots of judicial complaining that Bruin's test is unworkable and produces inconsistent results. The most common complaint is that judges aren't historians and that therefore they aren't able to perform a historical analysis like Bruin requires. But the historical quotes, I should put that definitely in quotes, the historical analysis required by Bruin is lawyers' work. It's entirely within the lawyerly competence to look at constitutional provisions, statutes, and cases that interpreted these things, right? These are legal questions. These are not historical inquiries requiring historians. The cases don't require, for example, determining whether King Arthur or Atlantis actually existed. It involves looking at historical constitutional provisions, historical statutes, and cases that interpreted those provisions. Right? Not surprisingly, the Supreme Court didn't need to rely on expert reports or testimony when deciding Rahimi, which again is the most recent case on the Second Amendment. Some post-Bruin inconsistency has been the result of what some scholars have called uncivil obedience, in which, again, quoting, lower courts take the Supreme Court's opinions at face value and pursue the logic of the opinions to their ends, end quote, to arrive at unreasonable and attention-grabbing, crazy results to criticize those opinions, right? For example, letting violent felons free on Second Amendment grounds, like that judge in the Southern District of Mississippi. So when you've got defiant and uncivilly obedient opinions combined with good faith attempts to apply Bruin, you necessarily have decisional inconsistency by design. Right? I think a charitable view of the confusion with applying Bruin's common law historical method to novel regulations is that judges no longer know how to do it. I think the more realistic view, given how intelligent and skillful they are, is that the confusion is an exercise in willful blindness that's manifested through defiance, uncivil obedience, and what you can call an intellectual blackmail that people will die, right?
So turning to the case that you focus on most in the article, it was called Firearms Policy Coalition versus McCraw. What was the issue in that case?
So it was fairly straightforward. It was a challenge to a provision of Texas law that forbade ordinary 18 to 20-year-olds for applying for concealed carry permits.
And starting with the Second Amendment's text, as Bruin requires, did Judge Pittman, I believe he was the district court judge in this case, did he determine that adults under 21 are among the people protected by the right?
He did. He said straightforwardly that young adults are, quote, members of the political community and part of the national community, end quote. And that they're therefore protected by the Second Amendment as they are by other constitutional rights.
You make a few points in the article regarding whether 18 to 20-year-olds are among the people that I wonder if you can expand on here. First, you write that, quote, to be denied the right to bear arms is to be denied inclusion in the polity. Why is that?
Yeah, for a few connected and related reasons. So arms bearing was, and in fact still is, the primary marker of political trust. So throughout history, including in England and the US, those who were truly part of the community had the right. And in fact, they also often had the responsibility um, to bear arms. They were in the US required to furnish their own firearms for militia duty, public watch, posse comitatus calls, and even routine travel to church. So possessing arms signified that one was a rights-bearing participant in collective self-government. Um, the flip side of that is that historically, disarmament tracked political exclusion. Um, when governments have stripped groups of weapons, it was because the groups were deemed politically suspect. So Catholics or Protestants, depending on who was in power, especially in England, if you were the opposite religion from the monarch, then your arms rights went away. Loyalists and freedmen here in the United States, etc. And these determinations were based on these group determinations rather than on individual dangerousness determinations. So arms bans functioned as tools of civic exclusion, shorthand for saying you're not part of the people. Um, and third, civic participation and self-defense are inseparable. So denying young adults the right makes them second-class citizens. The right to bear arms enables both personal autonomy and public service, right? Stripping a lawful group of that right makes them wards of the state or thralls of the state, not equal citizens within the constitutional order.
And you mentioned this earlier and explained in the article that 18-year-olds are punished as adults for committing crimes, including by capital punishment. Why is this inconsistent with laws that restrict the right to keep and bear arms?
Yeah, so there's a logical clash here, a double standard. Um, at 18, the law already treats you as fully culpable. The state treats these young adults as fully accountable for their actions when inflicting penalties, again, including capital punishment, and including in Texas, by the way, which still has capital punishment. Yet young adult arms bans say that the same 18 to 20-year-olds are too immature to carry handguns, and they strip this group, which is, by the way, violently victimized at a higher rate than other adults, of the means of self-defense. So, in other words, the state can't coherently claim that 18 to 20-year-olds are adult enough to face capital punishment for misusing arms, yet too childlike to exercise the parallel right and longstanding duty to keep and bear arms.
So moving on to the historical inquiry, Bruin provides that when a challenge regulation addresses a societal problem that has existed since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the law is unconstitutional. The challenge regulation is unconstitutional. Is there evidence that 18 to 20-year-olds kept and carried firearms during the founding era?
Yeah, there's quite a bit. So militia statutes and you know what I found myself calling after I wrote the article, unfortunately, communal peace duties show that the American legal order both expected and legally required 18 to 20-year-olds to possess, importantly, maintain, and publicly carry firearms throughout the 18th century. Starting with the militia laws, over 250 colonial and early state militia statutes obliged 18 to 20-year-olds to enroll and, to quote a common term in the statute, supply their own arms, um, or bear their own arms, or bearing their own arms, to militia service. I believe only one, Virginia, I want to say, didn't include this group. There were routine public carry mandates. So founding era rules sometimes required everyone, including young adults, to go armed on ordinary trips like to church, public assemblies, or when traveling abroad. Traveling abroad is another term of art. That means if you're going away from the area where you lived. Um, and there were the related duties of hue and cry, watch and ward, and maybe importantly, posse comitatus, which still exists today. 18-year-olds had to help pursue criminals, perform guard duty, and help keep the peace when they were asked. Um, and there was also more broadly a general practice and marksmanship. Contemporary observers noted that the founders and their contemporaries regularly carried arms in public from an early age, and young colonists were actually renowned marksmen, emphasizing youthful gun ownership on their part.
So what type of laws did the state prove? Well, I guess what type of laws did the state produce to convince the court that its regulation was consistent with historical tradition?
Yeah, so the state invited the court, Judge Pittman here, to rely on three categories of laws used in pre-Bruin Fifth Circuit cases that cases which did not satisfy Bruin's test, so that relied on old law, on the old test that we mentioned. So one was the infancy theory, which I mentioned. And the idea is that because at the age of majority, because the age of majority at the founding was 21, 18 to 20-year-olds could be denied the right to arms. But this isn't the correct level of generality, as I mentioned earlier. Given the available evidence specifically on the arms rights of 18 to 20-year-olds at the founding. And it assumes that minors default to having no rights that a court is bound to uphold unless the minors affirmatively prove that they enjoy the protections of a given constitutional provision. And as we said, that's just not how rights work, right? Another set of laws were prohibitions aimed at political outgroups. Again, ones we discussed, laws disarming oath refusers, freed slaves, loyalists, and importantly, individuals proven to be violent or dangerous. But the problem is, at issue here was a group disarmament, a group-based disarmament statute that rested on a blanket judgment of presumably dangerousness in the case of these young adults. And the laws that it relied on were based on blanket judgments of disloyalty or assumed danger. Rationales that can't sensibly be applied to law-abiding young adults, right? We need individual determinations of dangerousness, I think. There were also public safety rules about how firearms could be used, so powder storage ordinances, rules for handling arms during militia duty, time and place bans on celebratory or careless firing. These laws regulated dangerous use, not the foundational right to keep and carry arms. They left ordinary citizens, including young adults, rights untouched the rest of the time. Um, and post-war statutes limiting minors' purchase or transfer of certain guns, Reconstruction era laws that, for example, required a parent's permission to buy a pistol for a minor, or barred concealed carry of small handguns by minors. And even taken together, these laws don't resemble Texas's flat prohibition on public carry. Um, Only two of the 20 laws banned open carry. One addressed concealed carry, and the most just merely regulated sales.
Texas argued in this case that criminality peaks in late adolescence or early adulthood, and that this has been the case throughout all of American history. Why does that argument not provide a compelling reason to restrict the rights of 18 to 20-year-olds to keep and bear arms?
Yeah, and by the way, I think this might have to be our last question again, just like last time, because we've got about 4 or 5 minutes left here. But I think we do have time for this one. I think it amounts to collective punishment, right? Stripping an entire age class of civil rights because a fraction of that group might abuse it presumes collective guilt and metes out collective punishment. A decidedly un-American thing to do. Rights exist fundamentally so that that kind of punishment by the state doesn't happen. Um, Jeff Jacoby, a columnist for the Boston Globe, said it nicely from the perspective of raise the age laws, which proposed to punish young adults as juveniles in Massachusetts in a piece that he published a few months ago. And I'm just going to read a quote here from that. Quote, "The overwhelming majority of 18 to 20-year-olds don't commit crimes. People that at that age don't always act wisely. But that only means that means only that they are human, not that they are incapable of making rational decisions, resisting dangerous impulses, and abiding by the law. Public policy does not consider them juveniles because common experience confirms that they aren't. It is incoherent to regard people in their late teens as adults for all purposes mentioned above." And in his article, he mentions voting, military service, some of the things that I mentioned earlier. He adds marrying, getting a driver's license, and so on. Yet indulge those who turn to crime as children. History already knew about late teen crime spikes, yet never imposed a blanket gun ban. Under Bruin, that historical silence undermines Texas's prohibition. Young adults, as I mentioned briefly, also are more likely to be victims. National Crime Victimization Survey data show that 18 to 20-year-olds suffer the highest rates of violent crime victimization, and those violent crimes are the crimes against which a handgun is the most effective for self-defense. Looking at a CDC study and some other studies out there, and the CDC is certainly not anything one might call a pro-gun rights organization. There are other studies out there by similar groups, shows that defending with a firearm reduces victim injury substantially. So victims who resist with a firearm are substantially less likely to be injured than those who use other methods. So disarmament heightens rather than reduces victim danger.
So because I didn't get to the final questions, I'll just clarify that Judge Pittman did ultimately rule Texas's carry restriction for 18 to 20-year-olds unconstitutional. And we'll provide a link to your article that we discussed here in the description of the video so everyone can find it. I recommend they read it. And thank you, everybody, for joining us today.
Yeah, thank you very much, Joe. I'll say, yes, I agree. I think Judge Pittman did what Alexander Hamilton said judges had to do when rights are at issue. He resisted majority opinion as expressed by the legislature in protecting young adults' rights. And I'd add, he did that while having an easy avenue in the form of invalid Fifth Circuit precedent, contrary to Bruin, that he could have just relied on and passed the buck and upheld the law, but he didn't. He did He exhibited the uncommon fortitude that about which Hamilton spoke. But with that, thank you very much. Thanks for being our host or MC today. Um, and thanks to everyone who watched. A link to the CLE should be just below this recording. And we hope you'll tune in again for the next installment of our webinar series. And if you're not on our email list, please sign up. You can do that at firearmsresearchcenter.org.